Very enough. All right, let's call the case of the state versus Darien Johnson. It's case 24 CF 2134. May we have appearances, please?
Lexi Keyes for the state of Wisconsin.
Darien Johnson appears in person and in custody with counsel Will Anderson of the Public Defender's Office. He received a appearing specially for today. He's received a copy of the criminal complaints and we would waive its formal reading. And the address of the criminal complaint is correct. I don't think Mr. Johnson has been able to speak to a representative from the Public Defender's Office yet.
All right. And I think the deputies either have handed or will hand them a sheet that describes how to contact the Public Defender's Office to apply for representation. That's an option, sir. You're also free to hire a lawyer on your own or to represent yourself. Mr. Anderson will help you today. You're covered for today. I'm just trying to look to see if there's any specific branch we should be assigning the case to. It appears that he has an open misdemeanor case in Rock County. That wouldn't matter in terms of branch assignment, but it also looks like he's on a probation hold and that stemmed from a branch 17 case. If that's the case, then we need to get this case also assigned to Judge Conway. Attorney Keyes, any position regarding bail?
The state is requesting cash bail in the amount of $100,000 with the non-monetary conditions that he not have any contact with the victim's family. She's identified as RMH. That he not operate a motor vehicle at all. That he not use or possess any alcohol while case is pending. And that should he post that he report to pretrial services with alcohol monitoring. And have GPS with a curfew. I would leave up to the court as to what the specific hours of that curfew would be. I do believe, before I make my argument, Commissioner, that there is at least one or two family members of the victim's family present in the Zoom that would like to make a statement.
All right, thank you. I was not aware of that. Is there, maybe I'll see if someone's present. If you are, you can unmute your microphone. I see Anna Martin unmuted her microphone first, so we'll call on you first. Please feel free to share any requests that you have regarding bail or conditions of bail in Mr. Johnson's case. Ms. Martin, can you hear me?
Hi there. My name is Anna Martin. Yeah, can you hear me?
I can hear
Can
you.
you hear me
Yes, I can. Go ahead, Ms. Martin.
Okay. My name is Anna Martin, and my sister is Rachel Haft, who was the victim in this crime. So I did say a few words. Not to young adults making mistakes. I've made a lot of them myself. I don't always believe that one decision define who you are as a person. However, in this situation, I believe there are multiple factors that allow us to understand who Darien is as a person. For himself. However, the choices he made in the initial moments after the crash speak the most truth to his character. Based on my sister's spinal cord damage, her neurosurgeon told me that Rachel would have been unconscious upon impact. Also, she had obvious signs of bleeding from her head and leg due to laceration. And what does the conscious driver, Darien, decide to do within these initial moments after the crash? He decides to call a friend, not 911, for the unconscious, bleeding girlfriend next to him. Darien was only thinking about himself in those moments. Even in matters of life and death, Darien attempted to avoid police involvement rather than doing the right thing. Not only does he not have any respect for human life aside from his own, he clearly has no respect for the legal system. Of his financial situation, however, I do not believe his bail should be remotely looked for him to be a part of society prior to sentence no longer can or will be able to. But I'm also speaking on behalf of anyone else who would fall victim to his poor decisions. I would never want any other family or person to.
Ms. Martin, I think we were able to hear the vast majority of what you said, but there were some portions that cut out. There was a sentence there where you specifically said what you wanted to happen for bail, and perhaps I can have you repeat that part. No, I'm not hearing any response. Was there another individual that wanted to speak with respect to Mr. Johnson's case? If so, please unmute. I'm not seeing any at this point. Attorney Keyes, maybe we'll turn to you.
Thank you. I would note that Mr. Johnson does have a prior OWI from 2022, and he's not yet even old enough to legally drink. He's 20 years old. Here he was so drunk that he crossed the center line, went into a ditch, and crashed, fatally injuring his passenger. It is an Act 3 case, and he admitted to being drunk and being the driver to law enforcement. Here he is looking at mandatory prison time. And I think given all of the state's evidence at this point, as well as the Act 3 implications, this is a high cash bail situation. He, I would just note, has a limited criminal history. He was on probation at the time out of branch 17, as noted by the court. He also has open cases in Rock County and Greene County. There, he has bail conditions that seem to indicate he has a drinking problem, as they say, not to use or possess any alcohol, at least in one of the cases. I can't tell based on the notes, but at least, and he is accused of intoxicated possession of a firearm in Rock County. So I think at this point, given everything that we know about Mr. Johnson, the fact that 969.08 sub 2 does say that specific violations of bail can be a reason to increase cash bail, and the fact that this is an Act 3 case, that he is looking at mandatory prison time on, where someone is deceased as a result of his actions. I believe that $100,000 is the minimum amount that the court should order, and that's what I'm requesting.
Thank you, Attorney Keyes. I do see another hand is raised on Zoom. Maybe that's the other victim we were looking for. If there's another individual who wants to speak regarding bail in Mr. Johnson's case, please feel free to share who you are and what we need to know. Well, perhaps not.
Did you hear? Wait, did you hear me?
I can hear you now.
Sorry. Okay, did you hear anything that I said or no?
Is this Ms. Martin?
Yes, this is.
Yeah, we were able to hear, or at least I was able to hear the vast majority of what you said earlier. There was one chunk that cut out particularly bad, and it was the part where you said what you thought the bail should actually be. I know you began to say something about the bail and then we couldn't hear it. So feel free to state that again.
Unaware of Darien's financial situation. However, I don't believe that his bail should be remotely low enough to allow him to be a part of society prior to sentencing. I don't actually have a specific number, but that's kind of where I'm at. I'm speaking obviously on behalf of my sister, but also on behalf of anyone else who would fall victim to his poor decisions. I wouldn't want any other person or family to have to go through what Rachel did and our family is going through right now.
I appreciate your comments. I appreciate your sticking with it in terms of logging back in or whatever you needed to do to improved the audio. It did help a lot. So
Okay.
thank you.
Yeah, thank you.
And I need to turn to Mr. Anderson.
Thank you, Commissioner. We would be requesting that the court set bail in an amount lower than what the state has requested. The number that comes to mind for me is $20,000. I don't think there's any denying that this is a cash bail case. I also do not have a lot of information about Mr. Johnson's finances. He hasn't yet been able to complete an application to the state public defender. I imagine that's at least in part due to his medical situation. Would point out that he's a young person. Any financial resources would inevitably be coming probably from family members. All due respect to the victim the family member of the victim that we heard from here, bail should be set in an amount that Mr. Johnson is able to post. That is the purpose of bail. The purpose of bail is not to keep him in jail while the case is pending. And I do fear that a six-figure amount, like what the state has requested here, would have the effect of keeping Mr. Johnson in custody while this case is pending. I'm not sure $20,000 would make a difference, but I think it at least brings it down to an attainable for Mr. Johnson's family members if they were to perhaps pool resources. It at least sets a level that when bail is reviewed, if bail is reviewed at a future date, he doesn't have to bring things down from that six-figure number, which can result in multiple more hearings, more time in custody, which again is not the purpose of bail. While this may be an Act 3 eligible offense, the conditions that the state has proposed regarding pretrial services, alcohol, remote breath monitoring, use of GPS and curfew, those could be employed to protect the public and to ensure that Mr. Johnson is not drinking, that is not driving. Of course, the no alcohol conditions, so no operating a motor vehicle. As I review the complaints, I see Mr. Johnson as being cooperative with law enforcement at the scene of the accident. I'm remorseful about what happened, and I don't have any information about what his blood alcohol level was. Obviously, it was a bad accident and a tragedy that resulted that night. But I guess based on what's in the complaint here, he was cooperative. He volunteered information that inevitably will be used against him here. So he's not necessarily looking to avoid responsibility. And when it comes to cash bail, the purpose of protecting the public already addressed, but responsibility for coming to court, he has a limited criminal history. I didn't hear anything about missed court appearances. While there certainly is a significant amount of exposure in this case, but like anybody else who's charged with a crime, Mr. Johnson could have an opportunity to show that he can come into court on his own with considerable amount of cash in the game potentially, but not the six figures that would be prohibited for him to post. There's just been no history of missed court appearances discussed today. So I think that factor weighs heavily in favor of Mr. Johnson. So I think finally, as I look at this case as a whole, and I have no idea how it will go or where it will resolve, but I have to imagine that folks would like to see Mr. Johnson engage in some sort of AODA or alcohol related treatment. And I do believe that if the cash bail is set at the amount suggested by the state, that's going to be very, very difficult. You'd most likely end up sitting here in the Dane County Jail while the case works its way through the system. So something lower, but still significant. $20,000 is the number that we propose. Thank you, Commissioner.
Thank you, Mr. Anderson. I have reviewed the allegations in the complaint. They're supported by probable cause. This being an Act 3 eligible offense, I'm supposed to consider the quote unquote totality of the circumstances, which the legislature says includes prior convictions for violent crimes, appearance risk, the need to protect the community from serious harm, prevention of witness intimidation, and consideration of any affirmative defenses. What that says in really shortcut language is that I'm supposed to consider how much bail is necessary to assure his appearance in court, in part, but I'm also supposed to consider how much bail would be necessary in order to effectively protect the community. It's not likely to me that a low cash bail or even a cash bail and types of amounts described by the defense would achieve those goals. If I'm understanding this correctly, the defendant was placed on probation supervision with a no drink condition. He signed a signature bond in another county with a no drink condition. He posted a cash bail in a third county with a no drink condition. And now it's alleged that he drank and killed somebody as a result of that. I can't really envision a plainer application of Act 3, including its potential preventative detention sort of applications. That is a sea change in terms of how we look at bail from what has been the traditional view of things. If we were having this hearing 2 years ago and the bail standards were different, I think the defense argument would be a lot stronger than it is today. But under the current standards, what's described by the state is arguably even generous to Mr. Johnson. I will not set bail higher than that amount. I'm sorry, I will not, well, both are true. I will not set it higher than that amount. I'm not going to set it lower either. I'll set cash bail at $100,000. I normally don't do a pretrial services referral when somebody's also on correction supervision, but I think the sentence structure and the nature of his supervision might make that still a sensible thing to do, because even if he were to be revoked on that underlying sentence, it's likely this case would remain pending and that bail would be operative even after the service of that sentence. So it's appropriate to make there be a requirement that if he posts, he has to report to pretrial services by 10 a.m. on the business day following his release from jail. They're going to have conditions that he not consume any alcohol, that he not operate a motor vehicle, and that he have no contact with any immediate family member of the person described in the complaint as RMH. I know there was a request for GPS monitoring. I guess it's not entirely clear to me what that would be monitoring.
The request was designed to monitor the curfew that I requested.
I totally spaced the curfew. Can you repeat?
I didn't request a specific time. I did leave it up to the court, so that's entirely possible why it was overlooked.
Yeah, I guess I'm not so convinced that a curfew is necessary or appropriate in this particular case. If he's complying, if he's posted the bond, he's on pretrial services, and he's complying with the other conditions of bond, I don't know that the curfew is needed. I'll not make the GPS requirement or a curfew requirement. Mr. Johnson's entitled to a prelim within the next 10 days.
Let's get that on the calendar.
Okay, we'll do that. Mr. Johnson, good luck to you. I hope things improve for you, and also for you too, Ms. Martin, and the rest of your family.
Yeah.
Next up will be Karen Radifison, appearing by Zoom for the bail bond hearing.